concerns that have been presented to me that I think we have to deal with. A couple that I don't know how we're going to deal with. I'm going to say some hard things. I'm going to talk about some topics and use some language that's not for polite company. It's not what you want to sit around and talk about in your social time. But our duty, and I'm including Roger, our duty is to vet any law that we would propose to pass to ensure as best we possibly can that it achieves its intended objective and that it does not create what you heard from people tonight, unintended consequences, more harm than good, harms one in favor of the other. We've got to deal with those things. This is a really difficult topic. I don't need to tell you that. It's been in the forefront of the news and public discussions of every level of government and society generally. That doesn't need to be repeated, but now we have to deal with it. It's been presented to us. We have a bill, an act, an ordinance before us, and we have to make a decision about it. We have an opportunity to work through it and make it better or make a good decision about it, and that's what I hope for. So I want to apologize that we have to talk about hard things, just a little heads up. I hope you'll bear with me. So yeah, and by the way, you'll see Anna and I's presentations are crazy similar because I am completely incompetent. This is my first PowerPoint ever. First one ever. It's black and white.
That's the best part.
Mm-hmm.
Just text, no one has to read through your color or anything else.
There is a little bit of color in it, but it doesn't mean anything. It's just to highlight, separate a few thoughts. So thank you for bearing with me. First, I want to mention who's affected by this, because there have been comments about, well, it's really a small group, we're just plugging a hole, where you've heard a lot of these comments. I'm in charge of my own thing, yep. So small businesses in Tucker are affected. I just want to point out, we just adopted an economic development strategic plan. In that plan we adopted, it notes that there are over 1,200 businesses in Tucker with fewer than 10 employees. This is not a small pool of people or organizations that are going to be affected by this. There's at least another 100, it's not divided appropriately, so there's at least another 100, 150 between 10 and 15 employees. So we're talking about 13, maybe as many as 1,400 organizations in Tucker who fall into what's been referred to as this gap in the federal law that needs to be plugged. I'm going to mention some other things along the way, but let me say before I forget, I've reserved this room for Thursday, May the 25th. That's 2 weeks from this Thursday. I'm going to host a town hall myself. It's not a council meeting. There will be some rules, but they'll be my rules just to maintain some kind of order. One of the great frustrations, and I think all of us would agree, is that there just aren't forums where we can talk back and forth, where you can ask me a question and I can answer it, where I can ask you a question and you can answer it, where we can hash out an idea or a concern and find out whether it's really a concern or whether we're miscommunicating. So I'm going to host a meeting 2 weeks from Thursday, May the 25th, in this room at 7 o'clock for a couple of hours. I'll get some word out about it, but the idea is that we can just sit here and talk. I hope that'll help with some of this. So I'm going to hit on a bunch of topics or questions, concerns that I hope that at that time and at other times we'll be able to kind of talk through together. So who's affected? Small business in Tucker, lots and lots of them, including me, including several members of this council, including a lot of people in this room. What do I point out? Whoa.
You sure you don't want me to do that?
Property owners. What am I pointing at? Okay. Property owners in Tucker. So every person who owns 1 or 1,000 residential properties in Tucker is covered, because they've got to either, if they're renting now or might want to rent at some point in the future, they're going to be forced to comply with this ordinance, whatever form it ends up in, or face sanctions. It's a lot of people and it's no small deal. So I just want us to understand who we're talking about. This is, it's affecting a lot of people, as we'll see in a minute, in order to get at the few who I name later. This is a really important part of it to me. The ordinance states its purpose and intent. I think it's kind of cloudy. I think it's a bit muddled. I wanted to clarify the way that I look at it. The purpose of this ordinance is what it does. And what it does is create new protected classes of people. New descriptors of people become illegal forms of discrimination. Whether you think that's good, bad, or indifferent, that's to me what the purpose is. The intent is what the act hopes to accomplish. So it's got language, which we could probably all agree on, in or out of an ordinance, in our personal and corporate lives. We want to eliminate unjust, unwarranted, the ordinance uses different language in different places, but we all know what we're talking about. We want to eliminate abhorrent kinds of discrimination. Our decision, and I'm talking to our council, our decision has to do with how and whether that purpose and intent align, whether they're aimed at the same thing and achieving the same goal. But importantly, whether the desired outcome is likely to be achieved by this ordinance and whether undesirable outcomes are likely. That's for me how we approach this as a matter of creating law. Here's some specific concerns, and I'll try to get through them quickly. This is a new area of law. 2 counties and 13 cities have passed some form of a non-discrimination ordinance in Georgia. 2 counties, 13 cities. Most of those cities are in DeKalb County. But that means 520 cities have chosen not to, or have not gotten there, or have run into roadblocks, what have you, as have 157 counties in the state of Georgia, including DeKalb. The county that we sit in could have passed a non-discrimination ordinance like this anywhere along the way, and they may yet in the future. They have not. I can't speak to why they have not. I can only say that they have not. And as has been noted, there are dozens of court cases around the country. This is new law, new areas of law. There are dozens of court cases around the country to determine things like who's authorized to pass such a law, what definitions are appropriate or allowable. There's lots of questions tonight or mentions about the Constitution. It happens all the time that somebody somewhere passes a law and somebody else claims that law is contrary to the Constitution. We don't say, oh, it's okay if we make a mistake because it's already protected by the Constitution. That has to be hashed out in court. That's what the Supreme Court does. So there are cases, including one in particular that was mentioned tonight, the Supreme Court heard in December. We expect to hear their decision, narrow or broadly tailored, all those things, sometime in June when they typically announce all those decisions. And of course, there are a number in federal district courts as well that might be final decisions or might themselves go on to the Supreme Court. Here's one that'll set some people off, but it's true, and we have to face it. We are far from a consensus about the science behind various sexual preferences, orientations, and expressions, especially as to whether they are inherent and immutable, or choices in behaviors, or some combination, or in between definition. When we talk about passing an ordinance that elevates a new class of descriptors to be on par with what Black Americans have endured, what it took for women to get the vote just 100 years ago and well after the Civil War, disabled people, all the ones that are already ensconced in law, these are questions we're going to have to resolve, and we're going to have to be able to define, and we're going to have to be able to figure out and state exactly who and what sorts of characteristics we are going to declare illegal to discriminate against. It's going to be hard. The law relies on some really nebulous terms. A person or enterprise can be publicly accused, and this is important. When a person avails themselves of the process that's contemplated in this ordinance, it becomes a matter of public record. Just the fact that they accused somebody and paid the $50 filing fee. So a person or enterprise can be publicly accused of violating the ordinance based simply on the complainant's assertion that the accused party perceived that the complainant was part of a protected class. So you don't have to be part of a protected class to file a complaint. You only have to assert that the person who aggrieves you, if you will, perceived that you were, that they thought you might be this, that, or the other in the protected class that we're gonna create. That's very problematic, and I don't know how, maybe somebody will tell me tonight or in our sessions in the future, of another law where perception is the legal standard on which somebody can be found in violation of a law or an ordinance, what have you. Here's a tough one. And I don't put these here to be provocative, but I gotta tell you, I got word last Wednesday, I came back from out of town, I got an email from our 3 colleagues who said they wanted to put this on the agenda. So I started just Googling this subject of NDOs, discrimination, and so on. The ordinance as it's written, our ordinance, doesn't limit sexual preference, orientation, or expressions in any way. It just says, cannot discriminate against someone based on those 3 descriptions, or even the perception of those 3 descriptions. So, there's an organization called the North American Man-Boy Love Association, and I put their website there. I'm not making this stuff up. It's been around for a long time. They go around as if they're just the same, on par with everybody else. They are not, and if someone comes into an employer and lists NAMBLA on their resume, they cannot be discriminated against under the ordinance as we've written it. Just last week, Minnesota is one of the states that has an ordinance, in their case an act, a law like this. And in that act, it restricts pedophilia. It rules out pedophilia as a part of one of these 3 categories. There's a legislator in Minnesota who's proposed legislation now to strip that exclusion from the act. Are you following me? Their act says all these things are not to be discriminated against, but pedophilia, okay. They have a legislator presenting an act to say, no, we need to put pedophilia back in there as a protected class. These are the most extreme of examples, but as someone said earlier, the whole game around these kinds of ordinances is that people on both sides will find the most extreme case, make the most extreme claim, and we spend our time fighting those things. We spend our time arguing over those kinds of things. We get sued over those kinds of things by one side or the other. It's just part of our future. We're going to have to figure out those terms and what to include and what not to include. The offense targeted by this law is a moving target. How can the law define a protected class, which by its very definition is subject to change from day to day? Gender fluidity is included in the categories that we're talking about making protected classes. We're well aware, we read every day, and I can show you a stack of articles. A person today identifies one way, tomorrow they identify another way. I have a personal friend who I had a conversation with in the last 2 days, works for a very large national organization, who is facing exactly this issue. A woman who says, this week, my son is identifying as a woman, as a girl, and he wants to go in that locker room. We have to know, if we're going to pass a law like this, we have to know how we're going to deal with that. And that's one of the ones that I said, I just don't know exactly how we go about writing a law that the very definitions are by definition subject to change regularly. This law allows no exemptions for a business who wants to operate according to religious principles. I think I heard maybe one person mention this tonight. There are a couple examples here. I could give you a dozen more. Think of any restaurant that wants to observe dietary kinds of restrictions. Or any business. I'm not concerned just with creative businesses, people who want to build websites or take photos or bake cakes. Any business that wants to operate according to their own scriptural principles. Pick a business who wants to observe the Christian holiday calendar, but not the Muslim, or the Jewish, but not the Christian. Every one of those businesses will be faced with the potential for a complaint and a compulsion to change to accommodate members of protected classes under the way that the ordinance is currently written. Churches, religious organizations, yes, and I hear those concerns, and I happen to agree with a lot of them about, let me digress just for a second. I could give you 30 minutes on separation of church and state. The first thing to know is the whole point of the separation of church and state, which is not in any of the Constitution or the Declaration of Independence or anything else, it comes from a letter that Thomas Jefferson wrote to a religious organization in Rhode Island who asked him to get involved in settling a dispute between them and their religious neighbors. And he said, essentially, the state cannot get involved in religious matters. That's the separation he was talking about. The state needs to stay out of the church. If I run a business, if you run a business and you want to observe a particular scriptural calendar or principles, you should be allowed to do so. This act makes it illegal. We heard this one a lot tonight. The law, as we've written it, allows for no recourse against abuse or weaponization. There are some modest obstacles. You gotta pay a filing fee. I think it's $50. But there's no recourse against the kind of abuse we've seen in other places. There's no loser pays provision. There's no prohibition against, for example, filing a complaint and then go and telling the world that you filed a complaint as if your accusation is equivalent to a finding of guilt. Employers, churches, others, property owners, landlords, business owners, all subject to abuse, and we need to do something to protect against that. The cost versus the benefit of this law weighs heavily against it. My point of view, I think we heard it a lot tonight. I don't think there was anybody in this room tonight who falls into the category of they're a hater and what they really want is to be able to continue their hateful ways and discriminate against people, all the terrible things that we've heard recounted, and there are hundreds of those stories. This is a big club. It's a big bludgeon that we're putting in the hands of all kinds of people. And while enforcement might ferret out one or two Neanderthals, as I call them, bad actors, every person who I mentioned earlier, every property owner, business owner, is burdened with compliance and threatened with prosecution, including abusive prosecution. There's been zero evidence presented as to the scale of the problem or the likelihood that this law will resolve it. That doesn't mean it doesn't exist. It doesn't mean it can't be had. But in 4 years, I have asked at every turn. This council constantly demands data, background. When we do our business, that's what feeds into it. I have asked the original authors, the study committee, everyone who brings it up to me, and no one has ever provided any data about this. The idea that we have to pass it to find out, to me, is an abominable way to create law. And what other realm would we do that? And what other realm have we ever said, we're going to pass this so that we can find out if there's a problem. We're going to pass this so that we can, see how it works, and then we'll decide what to do. That's not okay with me. Again, it doesn't mean the problems don't exist or that the evidence can't be had, but we don't have any numbers. We don't have specifics of, we heard cases tonight. I don't want to appear unempathetic. 30 and 40 years ago, I want to hear, and maybe you'll tell me on May 25th, I want to hear what happened recently. If you want to come to me in private and talk to me about the specifics of who it was and what the circumstances were, I want to know. Because that's the only way we figure out how to write an ordinance that addresses that problem. That's the only way we know that our intentions align with our purpose, align with the outcome of all of this. And this is critically important. Our study committee, and I've asked several times, didn't consider any alternatives, didn't study other possibilities, and some people mentioned them tonight, things that we can do in between nothing, and an ordinance. I asked specifically at various stages along the way, did you talk about what happens if we do nothing? This goes to the previous question. How big, how bad, how prevalent is the problem? How pervasive is it? How much is it happening? How bad is it? What happens if we do nothing? Well, we've done nothing, I'm sure some of you will be quick to remind me, for 4 years. Tell me stories that have happened in the meantime. Tell me about the problem. Has it gotten worse, better, gone away? What's happened? And what if we continue to do nothing? I think it's a fair question and gives us at least perspective from one end to the other of what should we be doing as the government. There have been no follow-up meetings of the committee. So I formed this committee. I'm speaking to the not present gentleman who talked about me obfuscating, delaying, filibustering. I formed the committee. I did that. I appointed these 3 people to lead it. They appointed and asked and sought assistance from others. They met and met and met from the spring of last year until last September, and they presented a report. I spent 2.5 hours at a meeting, some of you will remember well, asking questions. Just asking questions. It's recorded. You can find it out there. You can watch it. I watched it a couple of days ago. I've watched it more than once since then to check myself, to remember the questions, to see if those questions have been answered. The committee met in September, provided its report in September. We met in a work session. I spent all that time asking questions. In the few days following that, we had kind of a debrief where we got together. That was the first time I ever met with the committee, by the way. They did all their work on their own, uninterfered with by me, but I met with them after the work session to just kind of debrief, talk about what would be next. There's been no meeting since then. The changes that you see in the ordinance as presented tonight versus what was presented back then, a few members from the committee collaborated to make some of those changes, and I know they got some legal advice and so forth, but the committee has not met since. There has never once, ever, in the 4 years, been a public hearing on this topic. This is the first time that we've invited the general public, come who may, here we are, tell us what you think. Tonight. It was good. It was important. We heard some things we needed to hear. We learned some things we needed to learn. We need to absorb those and continue to ponder them, continue to take them into account, continue to work them into the legislation. Tonight's the first night. I'm going to have a meeting on the 25th. Others might do the same. Y'all are welcome to come to mine. We'll figure out the quorum thing. If you're not participating, but just listening, I'm sure that our attorney will tell us that's just great. What we will do in terms of a second read and another public hearing of this kind or whatever, the council will have to sort out. First Amendment violations. This is big, and it's not just religious liberty issues. The law compels every property owner, business, and institution to publicly agree with the government, that's us, the government's dictate on a very individual personal matter. The government will have said, here's how it is. You toe the line, or you get dragged into court, pay a fine, have your name smeared around in the public. And here's where some of my color comes in. Diversity of thought, and the ability to disagree should not be subject to government punishment. You may differ. This law infringes on the right to freedom of assembly. A person in Tucker cannot decide to put together a company or a rec sports league or a variety of other kinds of gatherings, organizations, what have you, without agreeing to what the government has said they have to agree to in regard to these descriptors of new protected classes. You heard a lot about freedom of religion in a multitude of ways. I want to reiterate, I'm concerned about faith organizations. I'm concerned about schools attached to churches and commercial versus non-commercial property that they own and how the government tells them that they can use it. I am also concerned about individuals of faith who want to practice their faith in their public life being told by the government, you may not. All of this leads to distrust, disunity, and disassociation. I think what we started to hear tonight is the beginning of leading to better than that. This law is drafted on the premise that people will always and only behave in predictable ways based on the supposed inherent characteristics of the groups they belong to, that somebody says they belong to, that they say they belong to. We're better than that, and I'm not yet willing to give up on the ability of humanity to overcome its own shortcomings. I think some of what we heard in this room tonight is going to lead some of us to change the way we think and the way we treat other people in both directions. Drafting an ordinance like this on that premise is giving up. It's saying there is no solution but a government solution. The government has to step in, the government has to lay down the law, the government has to tell you how to think and what to say and what to believe. No dissension allowed. We have better options. We need to explore them. And tonight was the beginning of that. I think there's a better path forward, and I wrote this well before we heard from people tonight. Now that we've brought the public into the discussion for the first time, let's hear them out. They might be smarter than us. They might have better ideas than us. We may actually arrive at a solution we can all live with. That's my goal. Something we can at least all live with. We take it up all the time among council. Can you live with it? If there's one person in the group who just can't live with it, we keep working until we find something everybody can at least live with. I don't have to love it. I don't have to be charging ahead with it. We need to find a solution we can all live with, and I think involving the public in this way is our path forward on that. So that's all I have to say tonight. I want everybody here to know, I'm not sure we said it specifically, but the reason we do 2 readings is to allow people to absorb what they've heard, to allow people who legitimately, understandably, are living their lives, raising their families, running their businesses, playing sports, whatever they're doing, they are not paying attention to the Tucker City Council and whether it's about to make a significant change in law. So we have a first reading. We have a public hearing. Everybody hears the same thing at the same time. Whatever was rumored about what is or isn't in the ordinance, it's there now. That's why the clerk reads it in. That's why it's in our minutes. It is what it is. It doesn't yet include Roger's proposed change. That'll come. Maybe it'll end up in there, either between now and the second read or at the second read, or maybe a motion made to include certain language or strip certain language. That's why we do this. Tonight is the beginning of the process. I'm sorry for those of y'all who think 4 years is too long and we've been screwing around and all that. Tonight's the beginning. And now we've heard the beginnings of what people think, some things that could make it better, some things we should take to heart before we launch into creating new law. We'll have a second read. Can't tell you exactly when it'll be or what form the meeting will take or what the ordinance will look like by the time we get here or what might have to do while we're there. That's the process. That's what we're doing. That's why we're here tonight. That's it for me. If there's any other comments about the ordinance, we can take them or we can move on to item number 2.